How's everybody doing today? Thank you so much for coming. Um, Today is a really important presentation. I love the aspects that of the series that we've covered thus far. It tends to be interactive and hands-on, and I get to talk about experiences with my clients. And there's a whole other piece to it that I'm certainly not an expert on, and some of that is about the legal and long-term financial planning of families that are dealing with a dementia diagnosis or even a chronic long-term diagnosis where things have to be considered in terms of finances. So we're very, very fortunate to have Joshua Weinshack, who's the resident partner at Kramer and Anderson's Ridgefield office, specializing in trust and estate planning, elder law, and probate administration. He advises clients on wealth preservation, tax reduction, which we all could use right about now, and asset protection strategies. He leads the Fairfield County Trust and Estate Planning Group. He's a strong track record in contested probate cases and is involved in community services through Newmont's Health, Union Savings Bank, Meals on Wheels, and other organizations. He holds a JD and an LLM from Western New England University School of Law. And somehow in his spare time, he is also a competitive skier, outdoor enthusiast, and lives in Ridgefield with his family. So you're a busy man.
Yeah, well, I sound pretty good on paper.
Yeah, this is fabulous. So good to have you. And then we have Amy Fader. Amy and I have known each other for many years. We partnered first when I was working as a supervisor for our private department with our private aides. And Amy was working at Jewish Senior Services as a care manager and social worker. I convinced her to come on board to RBNA. I think I convince you? Kind of, because I really thought she was such an amazing wealth of information and resource, and she's taught me a ton through the years. So she came on board in our hospice department, did a fabulous job, and now has taken on a role of private geriatric case manager, because the need out there for somebody to help you all navigate these situations is just become greater and greater. And as therapists in a session, there's only so much we can do. So she is somebody that is available privately for as little as one session to ongoing sessions with you to help plan, help make doctor's appointments, help you figure out your next steps. So welcome, Amy and Josh.
Thank you for that.
Thank you. It is great to be here. This is obviously a topic that means a whole lot to me. Pretty much dedicated my career to it. And there is so much we can do to help people in these situations. And that help really starts long before there's a diagnosis. But even if there is a diagnosis, whether that's dementia or other long-term care needs, there's still a lot we can do. People usually come to us just a little too late, which is unfortunate. And our remedies are greatly limited. So I'm hoping today to give you a good overview kind of the subject matter and be able to kind of pinpoint, different techniques we can use to help you out. And I think we'll illuminate why early planning is the best intervention. That being said, I welcome questions. I want this to be more of a discussion than a lecture, even though I'm standing up here. There are so many different rules. There's so many different pitfalls to this area of the law. The rules are complicated, they're not easily accessible, and frankly, there's a lot of misinformation out there. A lot of people engage in self-help through advice they heard from a neighbor or through some sort of online group, and it's typically not the best advice. There's typically better ways to do it, or there's adverse consequences that they didn't think of. And so if you have a specific question, feel free to ask, whether that's for yourself, a friend, a family member. I welcome it. Or if you just kind of have a general question because you heard something out there, I am happy to put a little bit more light and color on it. So, very generally, as you can see from that initial stat up there, most Americans don't have wills. And that's pretty recent. Even with the advent of all these online legal Zoom and different online make your own wills, still a lot of people don't have. I would strongly disencourage people from going online and making their own wills, not because I want you to have to come into my office, but it's like self-diagnosis. It's like instead of going to see a doctor, you just go online and say, yeah, I think this is my issue and this is the medicine I should have. It's not a good way to handle. You wouldn't handle your healthcare that way, especially for long-term care planning, Medicaid planning, Title 19 planning. You don't want to be self-diagnosing. Like I said, there's a lot of rules out there. A lot of people that have wills, they're old wills. They did them when their children were young. They did them 20 something years ago. A lot has changed, not only in the law, especially around Medicaid planning, but also in your lives. Your health situation has changed. Your children are grown up. You have grandchildren. And so you don't have to get updates every 5 years, but every 20 years, it's not bad to check in with somebody. People ask, when should I start thinking about, having a will? Well, that's a different conversation. That's for younger people. When they have their first child, their family planning, that's when you should have your first will, probably. But when should I start thinking about Medicaid planning, elder law planning? I usually tell people when you hit retirement age, when you're around 70 years old. And again, early intervention is the best intervention, and we'll get into those reasons why. Um, you know, Very few Americans have living wills, healthcare directives, powers of attorney, HIPAA waivers. These are very minor documents, but boy, are they important. And the caseworkers that are in this room that work with those families day to day when they're needing healthcare intervention, when they don't have these documents, it makes it a lot harder. It's a lot harder on the family, and I will tell you, from a financial standpoint, it is a lot cheaper to get these documents than go through a conservatorship, which we'll talk a little bit about.
I can just add to those.
Yeah.
I work with a lot of families who had living wills. They made them up, but they never told who their health advocate would be. They didn't share that information with who they actually named, or they no longer talk to that person, or that person might have died. So it's so important to update those documents. You may have done them, and that's wonderful, but you have to make sure that whoever it is that you actually asked to be that healthcare, to be your voice, that they know your wishes too, that it's just not a name on a piece of paper. And those are conversations that are really important to have with the people that you select.
Absolutely. Absolutely. And we'll talk a lot more about that. And you'll be a big help in that selection process and communicating with the family, because family communication really is important, especially in this type of plan. There's other financial products out there, long-term care insurance. The issue with long-term care insurance, and I'm not saying that it's a great product if you have it, but a lot of times what's gone on is people bought them years ago. And as you get older, the premiums go up on a very steep curve. So they become almost too expensive for families to maintain when they need them the most. So people end up abandoning these policies. Or, people say, you know what, maybe I should have a long-term care policy, and you're already 65, 70 years old. They're either incredibly expensive or you're not going to qualify to get it. So you won't have it anyways. Some people have older policies that they've maintained, or they kind of have locked in pricing, which is great. But unfortunately, a lot of those older policies, their cost adjustments kind of changed with the cost of living increase, which has been on a very flat, minorly steep curve, where the cost of healthcare has been on a much more steep curve. And so there's a gap. Which again makes this type of planning important, because it can fill that gap. Even if you have long-term care insurance, your daily coverages might not be sufficient, or your maximums might max out well before the payment of the total cost of care, or people just can't afford it or get them. So again, we kind of circle back to this plan. All right. So beginning the estate planning process. All right, where are we going to begin here? Selecting the right attorney, the right professionals to help you with this. This is a very specialized area of the law. There are tremendous amount of rules. There's a tremendous amount of trapdoors. The law is constantly changing. They're constantly revamping these rules. There's lots of people that end up in court cases around these. So there's always new case law out there. There's new planning techniques. So you need someone that is up to date on this. If they're not up to date, they're not going to be very helpful. Frankly, we've seen a lot of planning out there that frankly did the opposite of helping, but was more detrimental. And so choosing the right attorney is important. Again, creating those proper estate planning documents. We'll talk about why certain documents are helpful and why certain documents aren't helpful. People hear, I need to avoid probate. Probate's this nasty monster, and I need to have a revocable or living trust to avoid probate. Well, probate is kind of unavoidable in Connecticut. There's no totally avoiding probate in Connecticut. So that's kind of one myth we can dispel. The other part is that a revocable trust is you, it's your alter ego. It's not protecting any assets. So when we get into talking about Medicaid planning, the spend down qualification, revocable trust, not helpful at all. And so again, working with someone that's going to know that and isn't just, lip service on the radio, makes a big difference. Properly titling assets and designating beneficiaries. Again, if we're holding all our property jointly, which we'll talk about later, you're avoiding the planning that your attorney might have done. These shortcuts that say, I want to avoid probate, so I'm just going to title things jointly. That way it avoids probate, goes right to my spouse, can be very dangerous. Same thing with beneficiary designations on life insurance, retirement plans. We just leave that to a spouse and then they need care later. They have to spend that all down. There's a better way of doing it, and we'll talk about what that better way is. But making sure that you coordinate your assets with your estate plan, again, important. And then, choosing other financial products, life insurance, long-term care policies. I don't sell that stuff, but I work with, people that have it. We talked about long-term care insurance, life insurance policies. There's some good policies out there. There's a lot that you can do now with life insurance policies to possibly convert them to have a long-term care insurance component of it. So, talking with an insurance professional that knows this stuff, you might have an existing policy that you might be able to convert or put a long-term care rider on there, or, manipulate it somehow that will give you this long-term benefit that you might really need, or you might have a spouse that needs. So again, talking to the right professional is important. Real quickly, how to choose the right attorney. Again, is this their concentration area? It should be someone that concentrates specifically in estate planning, estate and trust administration, with the specific on elder law. You should see that on their website. When you talk to them, that's what they should be talking to you about. One good thing is if you look at them online before you go to see them or when you speak to them, are they a general practitioner? Do they do real estate? Do they do divorces, civil litigation? Kind of, a jack of all trades, master of none. There are some great general practitioners out there, and there's certain areas, real estate, just, buying and selling a house. There's more simple matters out there that general practitioners are just fine for. So I'm not knocking them. But when we get into these very specific areas of the law, like I said, there's just so much information you need to know, and it's constantly changing, that you need someone that really does it full time. At least that's our recommendation. One of the biggest questions that when you meet with someone, see if they ask about your assets. I'm always surprised when I meet with new families that have done estate planning before or met with another attorney that they thought was helping them out with elder law. I never asked them about their assets. They just said, okay, we're going to do a will for you, or we're going to do a trust for you, and X, Y, and Z. But they never really asked about their assets and how the type of assets people have, how they're titled, matters a lot in this planning. Because certain assets you can do certain things with, others you can't. There's certain ways we want to title certain assets, other ways we don't want to title certain assets. So that configuration of assets is just as important as the documents we draw up. So if you're meeting with someone and they're not asking you those questions, that should be a red flag right away that they might not be the right person to assist you with this planning. Okay. So baseline important documents to have. And we'll get into these in more specifics. Powers of attorney, healthcare directives and living wills, HIPAA waivers, a Medicaid protective will, which we'll get into the details of what that actually is. And for certain people in the right situation, a protective house trust. There's other things that are more specific to people's situations. If you're living with a child, or you move in with your kids to help, care for you, kind of mitigate the need for nursing care or having to go to a facility, there should be a lease agreement in place. Not that you want to pay your children and they don't want you to pay them to live there, but it's a legal way for us to divert money from you to your kids. So that's protected money now should you need care. That's not money you have to spend down. If you don't have a lease agreement in place, the state says there's no reimbursement for love and affection. They're your kids, they love you, they're doing it because they love you, not because they want to be compensated. So the state is getting tougher on this. They want to see that formal agreement. So that's an easy way to, again, to start to divert assets. The other one that's simple to put in place is a care agreement with your children. So they might help you. They might drive you to a doctor's appointment, help you pay your bills, go grocery shopping for you because it's easier for them to get out of the house and do that. If we put a care agreement in place, we can again compensate them for doing that. Do you have a dog? Do you have a cat? You can pay them to be your dog walker, to help care for your cat at whatever is reasonable, the reasonable rate is at that time. But we need a formal agreement. And again, this isn't because we want to pay our kids to do it, and they don't want to take your money, but it's a way to divert assets away from you into a protected account that during a spend down process, they don't have to worry about. Yes.
What would a care plan look like?
So they're pretty basic and broad, right? Because we want them to cover a lot. So it's everything from helping with daily activities, like I said, banking, grocery shopping, transportation to doctor's appointments or other appointments, care for pets, could be housekeeping, gardening, mowing the lawn. We make it very broad so it encompasses a lot. We don't want to have to try to think of every specific little thing that they do, but we have a kind of a laundry list in there, but it's very general and broad.
What if the care is more basic, like ADL care, so like bathing, dressing, toileting?
That's all in
There
there
are
as
some
well.
that is. Okay.
Yep. So really anything that a child might be assisting with. And people always ask, well, how much can they be compensated? And it's really whatever is reasonable in the community. We're finding that to be around $25, $30 an hour, depending on the type of care they're giving, or if they have a specialty. If you have a child that's a nurse and you're living with them, because they have that nursing degree, they can be compensated a little bit more. Same thing if they're like an accountant and they're helping with finances, same thing. Yes,
What
ma'am.
is this called?
Care agreement.
Care agreement, thank you.
That is a protective care agreement, previous slide.
The protective house trust.
Protective.
No, it's something different. The care agreement and lease I didn't put them up here because it's a little bit more specific to people that are in these situations where this is a little bit more broad. But the lease, the care agreement, if you're in those situations, one, if you're moving in with a child to help with care, that sort of thing, you should immediately speak to an attorney. Because again, we want to get these in place early. It's always tough when I have people come in and they say, yeah, mom's been living with me for 10 years. Can I get compensated for it? Not really. We kind of have to start from when we do this document forward. So again, if you're having health issues, you're moving in with a kid, or you kind of have, it's just too hard going up and down the stairs in my house. I want to move in with my child. You should be speaking with an elder care attorney immediately to start getting these in place. So, first document that we're going to talk about, durable power of attorney. Again, these are basic documents. Connecticut changed their law with regards to powers of attorney in 2016. So if you have a power of attorney pre-2016, it should be updated. For a while, banks were saying they didn't like them if they were more than 3 to 5 years old, so they were rejecting them, which was a real nightmare for people because when do you use these? When someone needs it because they're incapacitated in some way. The banks would be, oh, go get them to sign another power of attorney. They can't sign anymore. They don't have capacity. So this became a real problem. So our state ended up creating a new power of attorney act that said banks can no longer do that. Banks still give people a hard time. I'm just going to say. But for the most part, they've been better about it. But there's a lot more in the new powers of attorney as well. I've even seen powers of attorney done after 2016 that were just on the old forms. Why? Because probably done by an attorney that doesn't specialize in this area, didn't even know that there was a change in 2016. So, it's a good idea to have someone look those over from time to time. Why are powers of attorney so important? When you're not able to make financial decisions for yourself anymore, or you're just not able to get out of the house to go to the bank, this document allows someone to do that. All right, so it's everything from banking, dealing with the IRS, making gifts, moving assets around. Again, when we're planning for Medicaid, especially if someone needs Medicaid assistance now and they come into us, there's a lot of assets we need to move around between a husband and wife, if there is one, or other family members. In order to do that, we're going to need a power of attorney. If that's not in place, we have to go get a conservatorship. Now, a conservatorship costs a whole lot more money and it takes about a month to get. And if we add in a contesting family member because your kids don't get along, or there's an Aunt Susie who thinks she knows better, whatever it might be, that's going to drag out the process. It's going to, again, make it a lot more expensive, and it's going to take a lot more time, and it's so stressful on the family.
Yeah.
That you guys can speak to
And
that.
that month can turn into years. So
Mhm.
again, something you want to avoid.
And all that time, if we're private paying for care because we can't apply for Medicaid, that's a lot. And money starts to disappear real quickly because of that. And all we needed was this very simple document that costs under $200. To have that in place. One of the things about powers of attorney is who do we choose as an agent? What about alternates? Okay. One is who we should choose is someone that we've expressed our wishes to. It shouldn't be a closely held secret. They should know you. They should have some familiarity with your finances. A lot of times people pick their children or another close family member. But when we pick children, especially, or other family members, if we're going to have people work together, we want people that work well together. If your kids have different philosophies on finances or political views or whatever it might be, these are all things that cause friction. And when there's friction, it causes problems in using these, because if they're joint, they won't sign off on transactions together. It creates a stalemate. They end up in court fighting about it. Or one person's doing something and it's upsetting the other one, they get an attorney, now we're in court again. We want to avoid all that. So unless your kids or family members really, really get along with each other, don't name them together. Name one, then the other. And I know that can be hard sometimes to do, but if they're fighting, it's not helping you out who needs the assistance, and it's only causing more family friction. Alternates. It's a good idea to have alternates. People do these, lots of time goes on. I'm not people's favorite person to see. They're not coming in to see me every year to update them. And so life happens, life changes, people forget who they put down. They just know they have a power of attorney. And like you were saying before, sometimes that person's passed away. You no longer have a close relationship with them for whatever reason. Or they just have a whole lot going on in their life. They're one of your children, all of a sudden they have 3 children, or they're going through a divorce, and they're just really not able to give it the attention that it needs. So choosing an alternate just in case there's a situation where that main person's not able to help you out, again, is helpful, because we don't want to be in a situation where we're ending up looking for a conservatorship because we don't have some.
So how do you choose, how's the alternate come into play then? So if the first agent is not
Available.
do they say, I can't handle this right now, and then it just moves to the alternate, or how does that typically work?
Yeah, so again, banks are a little difficult. So if we know someone has passed away, it's always better just to get a new power of attorney. Otherwise, we have to prove to the bank that, or whatever financial institution it is, I'm picking on banks, I'm sorry. But we have to prove to them that they're not available. So a death certificate, that's an easy one. Someone that no longer wants to serve, because they have stuff going on. There we need, them to sign a resignation and have it notarized. So again, there's more process involved. Or if someone just lacks the capability, we might need to show that they're they lack that capability. That gets into a little bit more gray area. It's easy if they have a conservatorship, but if they're not conserved, we might need a doctor to sign off on it. Doctors don't like signing that stuff because they hate getting sued. So you might be tough to find a doctor to do it, and then you still need banks legal to approve it, which they might be wishy-washy about. So if they get wishy-washy, they're gonna probably deny it. So again, important to update. Alternates are good, but if we know that that person's not available, let's just do it. Same thing if we move out of state. Wills, trusts, those documents transfer from state to state pretty well. Powers of attorney, healthcare directives, these documents we're about to talk about, they don't. Why don't they? They should for the most part, but every state kind of has their own rules, they have their own forms. So when you go into a bank or working with some administrator and they look at it, if all of a sudden you're in Florida and they're looking at a Connecticut POA, it's not what they're used to seeing. They're gonna scratch their head and say, I gotta send this to legal. It's never what we want to hear in these situations, because it's usually not the outcome we want. So again, if you do move out of state or you're spending half your year in another state, for an inexpensive document, let's just do a Florida one. Let's do a New York one. It's worth doing just so we don't run into these problems.
And people should know who they choose. That's important. Often, so many people don't tell the person that they're, whether it's a healthcare practice, but they just name someone and they never have the conversation to make sure they also have your same values, because they may be choosing someone who doesn't necessarily agree with your choices. Whether it's healthcare or maybe you want to be a DNR and they don't necessarily agree with that philosophy. You want to make sure that whomever it is that you choose for these documents is aware and knows exactly what it is that you want.
So at what point, can you speak a little bit about, let's say you've got a case where mom has dementia and she's designated her son or mild cognitive decline. At what point does the POA trump the decision-making of the individual?
It never does.
Okay,
So a power of attorney never takes away an individual's right to make decisions. Only a conservatorship can do that. So that's through the court system. So a conservatorship is a big step up from a POA because it takes someone's decision-making ability away from them, because it's felt that they are unable to make proper decisions and it could lead to harm, whether that's financial or whatever you can think of. And so that's a big step up. A power of attorney runs kind of parallel to the decision-making ability of whoever granted it. So, if someone calls and, some sort of scam, or someone's, they're going to the bank to take money out, even if they are in cognitive decline, they still have the right to do that. So sometimes we reach a situation where someone is susceptible to being taken advantage of, or is going to the bank and taking out a lot of cash and no one knows what happens to it. It gets lost, they're hiding it, things like that. Then we say, all right, power of attorney is helpful, but we are at the level where we do need a conservatorship to really protect that person so they can't do that. So that does happen.
and what is the product, and I'm asking because this actually comes up a lot with the, the levels of dementia as people get more severe. We've had to, answer somebody or direct people in the right direction around these questions. But so if that were the case, somebody would have to be deemed incompetent by a doctor.
Well, so the court is whom deems them incompetent. Part of that court process is a medical evaluation.
Right.
So, for an involuntary conservatorship, there is a medical evaluation that needs to be done and presented to the court. They have like a standard form that's done.
Gotcha.
But the court ultimately is making that decision.
Yes, so they look at all the evidence. The person being conserved, they don't have an attorney, is appointed a court attorney so that they're represented as well, so it's not lopsided. So it's a very, like I was saying, it is an involved process, and when people need them, it is what's necessary to be done, and it's very helpful, and it does provide a lot of protection. But if we're just talking about simple moving of assets, paying bills, we don't have those big risk factors. It's nice to have the power of attorney and not have to go through all that, because it is very upsetting, especially someone that is in decline. It can be very confusing. It can be very frustrating. A lot of times people that are in decline or, well into the disease, there's a lot of paranoia that comes along with it. So now sticking them in court and saying, hey, you're losing your decision-making abilities, is only agitating that situation. And so that's something to be aware of. So to the point we can avoid it, we like to because we don't like to agitate people, but sometimes it's just necessary.
I was gonna say, we usually run into it when the family is at a crossroads where, you know, the family member, let's say, is living alone and is unwilling to make changes, safety changes, either by getting a private aid or putting safety measures in place in the home. They're falling a lot. 911 is having to be called a lot. And the person does not have the awareness to understand that they can no longer safely live alone. That's usually when we
Yeah.
see it, when it's either you need to have private care in the home and safety measures put in place, or you go to a facility. So a lot of times people say, well, as a POA, can I make this decision? And it sounds like the answer is that would need to go to another level of being deemed incompetent, and what's the first step of that? If you've got somebody that is living alone and that's falling a lot or unsafe, is the first step for us as clinicians, or Amy as a social worker, to get protective services involved or a social worker involved to, start the conversation of this.
A lot of times, it starts with family.
Mhm.
So if there's close family that is involved, that's
Yeah.
usually where the conversation starts and the recommendation, hey, I think you need some more advanced planning here. You should
Yeah.
speak to an attorney about a conservatorship. Then probably a social worker. Protective services is usually last on the list because once they get involved, there's no kind of calling them off. Not that you want to call
Right.
them off, but it escalates the situation. But
Okay.
sometimes that's necessary if we don't have close family that's able to kind of step in here. And then at that point, if there's a conservator needed, the court would appoint a court-appointed conservator. But a power of attorney really is only for financials. It doesn't give you the power to move mom or dad to a facility. Or, it allows you to hire caregivers, but if they're like, hey, you can't come into my home,
Yeah,
they're not coming
say
into the
that,
home.
yeah.
They're able to say that.
And,
So
and sometimes people make poor decisions.
Yeah,
And it may not be
yeah.
that they have any cognitive decline, it's just that they don't want anyone in their home, or
Right.
they're refusing care, and a lot of gray in, in working with
That's
families.
kind of why we tell people have these conversations before the dementia
Yeah.
progresses, or as soon as you
Yeah.
find out. And people always
So-
say to me, what's
so
the
important.
importance of getting that diagnosis in the beginning? And I think one of the reasons why is so that that that's the time to have these conversations before somebody gets into a later stage where they can't.
Exactly. Yeah, so important. And I know this is not like a fun, sexy topic, but it is really so important. I've seen so many families not happy, and it really very
As the
complicated.
spouse of that person that is no longer competent,
Mhm.
I mean, do I have any entitled rights, or do I actually need a conservative?
So unfortunately, you need a conservatorship. You need the documents in place. Spouses are looked at, so as far as who might get appointed as conservator, you as the spouse are the favored person by the court. You have the closest relationship by far, so that relationship definitely gets favor, but in order to make decisions for someone, if they're being resistant, to override that, you do need the court.
And could any lawyer who specialized in elder care draw up that document or do whatever is necessary to set up a conservatorship?
So the conservatorship is a little bit more specialized because it is a court proceeding. You're gonna want someone that's done conservatorships before. The court proceeding, not to get technical, is also ruled by the rules of evidence. So there's, objection, sustained, how you present evidence. There's a certain procedure for it. So you're gonna want an attorney that understands that procedure, especially if it's contested. If it's uncontested, it's a lot easier. But if we have family members that are kind of bidding for control, or have someone that's really resistant to it, that's kind of on the early stages where it's not so obvious that they totally lack capacity, you're gonna want an attorney that does these.
And you'd have to go in there with evidence of
Yes.
the lack of decision making.
Yeah, and that's where the attorney comes in. They're used to putting that together, the medical evidence, all the family stories and, incidents that have occurred, things like that.
But again, the spouse is favored, but still has to, if it's contested,
Yes.
answer all these questions.
Yeah, and the court, most of the time, even if it's not contested, they still want to make sure that what they're doing is putting this person in the best position.
Sure.
Safety wise, financial, personal safety, all that. So, the court evaluates that. So there are some questions, but again, if it's not contested, the court quickly does the right thing. It's not, they don't beat people up.
Is it the kind of thing that you could like, if I got a diagnosis of dementia, but I'm still have my wits about me? Can I say I want to do conservatorship
Who's gonna guess that?
now? I just,
So-
I give it to my husband, you handle it. Can I do
Yes.
that now? And is that a better thing to do?
So in some cases, yes. And we deal with that. It's called a voluntary conservatorship. So for a voluntary conservatorship, we don't need the medical documentation. So it's a much more informal procedure at the court level. So as long as the person that's voluntarily giving this, they have to be present at the hearing. The judge is going to ask them questions. If they seem like they lack capacity, they're going to say, I'm sorry, you're going to have to do an involuntary. But if the person says, hey, I know I'm starting to have some issues, or you know what, making financial decisions and decisions about, who to hire, this or that, is just way too much for me. I just want to give it to somebody else. The court does look on that favorably, and we do a lot of voluntary conservatorships in those situations. That's where we always like to start, because that's not agitating, right? If we can get someone to go along with it, that's great. But then there's kind of that line where someone either doesn't have enough capacity, or they think they're totally fine, or they have the paranoia where they're not going to go along voluntarily. One other thing I'll say about powers of attorney before we move on. From a financial end, a lot of people say, you know what, I'll just put my kids on my bank account. I'll just put them as a co-signer on the account. I'll make my account joint. That way they can make all the financial decisions. They can write checks, pay bills, move money. And it doesn't, I don't have to go to an attorney to do a document. The pitfall with doing that is they're an owner of that account. If they get divorced, if they get sued, from a car accident, they go through a bankruptcy, all of a sudden, this creditor is attaching your account, and that's not what it was meant for. And so we don't like that, because it puts our clients at risk. The power of attorney is different. They have no ownership rights of that account. They just have signature ability to kind of be your alter ego, but their problems don't become your problems. And that's something we always want to avoid with clients as well. So again, little shortcut that some people take that has unintended consequences.
And Josh, could you just define, in case, I remember first hearing those words, and I needed a bit of an explanation on revocable versus irrevocable trust.
Okay, we'll get into that, but a revocable trust is you. So it's a document that you set up. It runs under your social security number. You can put property in, take property out. They're very good for certain types of planning. They are absolutely useless for this type of planning. For long-term planning, thinking about Medicaid, it is just like having it in your own name. It provides zero protection. So while they work really well in certain situations, this one, no good.
Revocable or irrevocable?
Revocable, or
Okay.
people call them living trusts.
Okay.
Irrevocable trust, we'll talk about one later. That is something totally separate. It has its own tax identification number, and there it's considered a gift. If you put property into it, you are more or less dividing yourself from that property. So it is no longer yours. You can't make changes, you can't access it. That's what provides protection. Property that goes into an irrevocable trust gets protection. And there's certain rules around that we'll talk about a little bit later. But those are the fundamental differences. Living will, healthcare directives. In my opinion, these are probably one of the most important documents. While money is money, if a bill gets paid late, fine. If we're not able to move around some assets and we lose some money, that stinks. But healthcare, if you need a healthcare decision made for you and no one's put in charge to do it, that's you, that's your health. You're laying there either not getting the course of treatment that you would probably preferably want to have. You're being kept alive maybe when you don't want to be. It leads to a tremendous amount of family confusion, family tension, because emotions are running high. Because again, this is more than just money. This is typically a parent's health, a close family member's health. And people have different views on what should be done. Feelings from childhood come rushing to the surface in these situations. Sibling rivalry all of a sudden just bursts in this. mom loved you more than me, I got more hugs than you. You won't believe what we hear, but it pulls families at the seams because there's not a plan in place. These documents aren't complicated, but what it does is it expresses your desires with the type of medical treatment you want to have, who you want in charge of it. It creates that family plan. That way, even though one child might be upset that, brother was named over them, or ahead of them, but that's the way it is. All right. And they can have feelings about it. They can't take out their frustrations. That only puts the parent as the victim because nobody can make a decision. So what do these documents do? It does three things. One is it appoints someone to make medical decisions for you. It creates an agent for you. While you're able to make your own decisions or you're conscious, you're still in charge. They can't override you. But if you're not conscious, you're no longer able to make decisions for yourself. This person is able, whoever you appoint is able to make those decisions. And it's not just end of life decisions. It can be course of treatment. You could have some other ailment, cancer, been in an accident, and do we save the leg, not save the leg, not to be morbid, but these are issues that come up that aren't end of life decisions, but decisions somebody has to make. And if there's not someone in place, the hospital typically takes a more hands-off, conservative approach. They don't force people into treatments. And so you might want that. So appointing someone to make that decision is very important. Who to appoint? Again, if you have kids that don't get along or family members that don't get along, don't share the same ideologies, have different religious, political views, all these things come into play. If you think there's going to be an ounce of friction, it's not worth it. It's not worth it for you and your health. It's not worth it for your kids and their relationship. What I always say to families is, I want your kids to still have Thanksgiving together when this is all over. By not having this in place, appointing people together that shouldn't be appointed together, they will not have Thanksgiving. And so we want to avoid that. So choosing someone that they're going to get along or one over the other. The other thing is you need to make their wishes known to them. You need to talk to them about what you want. Part of that is an end of life. So these documents also have an optional provision, which is a living will, which says that if your condition is terminal, you have a relatively short period of time to live, that you don't have any brain activity, that you don't want your life unnecessarily prolonged by artificial means. Still says that you can get, pain medication, things like that. But, it does set what your intentions are. Now, that is not a green light for the doctors to see this if you've been in an accident or, you have a bad condition. They do not make that decision. Your healthcare agent makes it. So what that living will is more guidance. So that way we don't have family members arguing over what someone wants. And I think we all remember back in the 90s, the Terry Schiavo situation that went to the Supreme Court, that family fighting, the husband versus parents. It's a nightmare. It went on for 7-8 years. That poor woman, regardless of what her wishes were caught in the middle of it. So that's what we do not want. But ultimately, your healthcare agent makes that decision of when it's time. They say, no, we're going to give it a few more days. We're going to give it another week, another month. We're going to try this treatment. We're not. Or when it is time to make an end of life decision, they can make it. So it's important, again, to have that structure in place. Did you have a question?
These are filed with the hospital as well.
So what hospitals aren't great about keeping records of these, believe it or not. So anytime you go to the hospital with a family member, I say bring it. It's almost like, many years ago when you were having your children, you had your little to-go bag. If you have someone that has medical needs or you think you might be finding yourself in the hospital, it's not a bad idea to have a medical go bag again. And this document would be one of those in there.
So all my clients, I make a critical care document. It's as simple as this. I have a folder. I make sure that there's copies made and the people who are appointed, their healthcare proxy also has a copy. But I leave it with them. They don't always remember to bring it to the hospital, but I always tell a family member to try to remember if they can. I had, back when COVID first hit, I had a client I was working with and he wound up in the hospital before they even knew what COVID really was. And he did not have any of his critical care documents on him. He had no living relatives. And I knew that he was wanted to be a DNR. I got into his home, I found his critical care document. I bought it gowned and masked to the hospital, and because they were gonna put him on a respirator, and I knew that I had to be his voice, so I had the documents and was able to do that for him. So it's really important that you have them updated, you have copies, and you give them to the people in, in your, both your personal life and your medical community as well.
Yeah, and one of the things, this goes back to selecting an attorney, is how they give you documents as well, kind of matters. Are they gonna create multiple originals for you? Like at our office, we do lots of multiple originals, not overly so, but we wanna make sure that people have a nice bound set of all their documents, they're all in one place. Then we give them 2 loose originals, one for them to hold on to, and then if they're, especially if they're giving one to a child or someone else, that they have another one to do so. That way, if there is an emergency in the middle of the night, kids can't come to your house to get this document, that they have one. We also hold on to one original. So that way, if there is an emergency, they can call our office, and we have a 24-hour answering service, so every now and then, I get woken up in the middle of the night, or I'm out having dinner and I gotta run across town to my office to fax, one of these to a hospital. But that should be a service that is available. There should be enough documents that it's not, oh, I got one original and I don't know where it is anymore. There should be enough paper to prevent that from happening. I'm glad you brought up the DNR, because there's a lot of sometimes confusion, there's a lot of technical terms. Is a living will a DNR? The answer is no. A DNR is typically for much more advanced end of life care. Someone that's on hospice or has been living with a very bad disease for a very long time, that if anything happens, they get stung by a bee and go into anaphylactic shock, they don't want any care. It's hands off. That's not a living will. A living will, you go to the hospital, they do everything they can to resuscitate, revive you, bring you to a stable condition. It's only from there that if your condition kind of meets those standards that I spoke about, they talk to your healthcare agent and say, do you want to continue, kind of artificial life support at this time? So it's a decision that's made there. A DNR, typically people have the DNR bracelet. That way, if first responders show up, it's supposed to be pretty much hands off. So I always get that question. So I wanted to make that distinction. So thank you for bringing it up.
Thank you for clarifying that.
That's a
Important
lot.
document to have.
The other thing this document does, which we've been touching on a little bit, is appointment of a conservator. So it also makes your recommendation of whom you want the conservator to be. We still have to go through the court procedure, but the court will weigh heavily on your decision that you made while you were competent of who you want in charge of you if you're not able to. So again, this prevents that family fighting. Who's going to be in charge of mom, dad? There's a lot of players, not just children. We have siblings that throw their hat in this ring. So we want to make sure that it's clear determination of what the line of succession is. We don't want people fighting. I know I sound like a broken record. I just hate seeing it. It's the worst thing to see in my office. So, any other questions about healthcare directives? Yes.
Lisa, if you go back one page,
Sure.
This is the question is, the top. Am I looking at 2 different documents? Is there a living will and a healthcare directive?
So
Or are
it's
those
nice.
interchangeable?
Yeah, so they're not interchangeable. They're compiled under one document. Connecticut's nice, and they let us do a healthcare directive and a living will in one document. Other states make you have 2 separate documents.
Okay.
I can't charge as much because it's in one document. If I had to,
Do you use the 5 wishes?
I think the 5 wishes is, yeah, it's a good starting point for people to kind of start thinking about what they want and making, those decisions, how to choose someone. And I think it's a great thing for people to give to the family members. When we create these documents, we can't think of every possible situation that might arise. The 5 wishes is almost a little too specific in certain areas, where we might have a situation outside of it. And if our document is very specific, it's, well, did the person that created this document, did they intend to have any sort of powers outside of these wishes? And so our documents tend to be a little bit more broad. We put a lot more faith in the person that we're appointing. But the 5 wishes is a very good thing to give to that agent to kind of go through some of those more specific circumstances.
Are there situations where someone might have both?
Of course, I mean, they could have
Does
both.
one trump the other? Yeah.
You end up with competing documents, and if one person's pulling on one and another on another, the hospital's gonna say, we're stepping out of it, you guys go figure it out in court. So the unification of documents is good, that's why I like the 5 wishes as kind of a worksheet.
Yeah.
For the family, but not being an executed document, I think. Works better, it falls under the state statute, it's in the state form, and it hits on a few things that the hospital wants to see. And again, it gives more broad decision-making ability to your healthcare agent. But I do think, again, the 5 wishes is a great worksheet for the family, especially, it's great to start the conversation. And it can be a really difficult conversation.
I'm gonna bring you a copy. It's
We
really,
recommend that a lot.
we recommend
Amy,
it a lot.
yeah.
It's a booklet and the 5 wishes, and it really talks to what exactly you want, but a little more holistically. Like what you want your end of life to look like and who you appoint, and it has to be notarized by 2 people, but it serves as a healthcare, a living will.
Mhm.
I will get you a copy. I have one here.
And something
Show
is
you.
better than nothing.
Right,
I
and
will
we've
certainly
used it in those
say.
cases where
It's
like, if
good
we
to
just
get
make
your
something,
head- It's just a
start a
good
conversation.
exercise, even, sometimes I review mine and I make some changes, it's just something good to start thinking about what you want really for your own.
And I
life.
mean, it goes even as far as, what music would you like, right? Things like that, which sounds silly. You'll see kids
Oh, yeah.
arguing in the hospital about what mom liked to listen to.
Or, thank you, so that's, I'm just going in. I
There's
worked
almost
with
staff in
this
here.
for a few years prior to this role, and I can tell you that a lot of families didn't know what their loved one wanted.
Yeah.
They would have loved that information. Do we want music? Does she want to be forgiven? Like, do you want a chaplain? Do you want someone to come? There are things that you don't even think about, because these are conversations we don't. I mean, I love to have these conversations. Nobody wants to talk to me, but I think these are so important. But there's so much that does happen at the end of life, and I've seen it in my experience with working with families, that it's just a good document to sort of do a little, and you don't have to use it as the end result, but it's a helpful tool.
This document does not put anyone in charge of, is there a chaplain versus this or that, what music is listened to, this is medical. But like you said, that's families, certain families, if there could be a disagreement, and you'll know that your kids are those kids, they'll have it, so if we can cut down on that, the better, go ahead.
But that's something could be covered in a notified instruction too.
Yeah, absolutely. Anything that's an expression of your wishes, and it's always good to have a conversation, because it's good that, because questions come back at you and you give clarification, even though I know they're hard conversations to have. But writing stuff down is even better, because people interpret conversations differently. Sometimes people hear what they want to hear, they omit things they didn't want to hear. So, whether it's 5 wishes or a note of instruction of some of your more personal, desires around end of life, I think that's all very helpful. Next up, HIPAA waivers. Okay, HIPAA, something we hear about all the time, healthcare privacy, all right? So anyone over the age of 18 has a right to privacy when it comes to health. So the only people that the doctors typically speak to are spouses or people named on the healthcare directive. So a lot of times we have other family members that might want to call in and see how you're doing. You might have kids that live out in California, and they're on a different time zone, or they live abroad, and they want to call and see how you're doing, talk to the nurses station. Or, they might want to speak to the doctor directly, mom is, 87 years old, and the doctor's talking to them, giving them all this medical information, and the kid can't be at the meeting for whatever reason, wants to call and talk to the doctor. Doctor says, sorry, I can't talk to you. So we're putting a lot of pressure on, possibly an elderly spouse in these situations. The HIPAA waiver allows access to information. So it basically says the people that you name in it, children, your brother, whomever it might be, they can call, see how you're doing, but not make medical decisions. It's not for making medical decisions. It is information only. I don't like to create a long laundry list because it drives the nurses crazy. Because they don't want 20 different people calling in asking the same question. But, you know, you name your spouse as your healthcare agent, you want your kids to be able to call, especially adult children, call, see how you're doing, possibly ask questions, things like that. You know, those are the people that you want to name on that. But we need a specific waiver because of HIPAA laws to do so. And HIPAA violations are taken very seriously. Hospitals that get slapped with HIPAA violations become very hyper focused on HIPAA, sometimes overly so. But do hospitals violate HIPAA? Yeah, they do. And so people say, well, I didn't need it to talk to the doctor. And it's like, yeah, well, sometimes you don't. But it's an inexpensive document. It's good to have in place because if you don't have it and you run into, you know, a hospital that is taking it seriously, people are going to be locked away from information and it's going to be aggravating in an already very stressful situation.
Josh, about that, so if I had a HIPAA waiver, if my folks filled out a HIPAA waiver and it's in that yellow envelope,
Mhm.
do I have to have like a copy of it and then I'm talking to the doctor, they're like, oh, no, I got a HIPAA waiver, and then they like show it to me? Is that generally how it works?
You know, yes, they're gonna wanna see it, and
That's
so
fine.
whether your parent has it, or that's why I said it's good to have multiple originals of these, because your parent might not have brought it to the hospital, or it's at the hospital in a folder, but no one's there to retrieve it for the doctor, or it never got put on file. It's good for a child to have it so they can fax it in, or for the attorney to fax it in. You know, every situation's different. You know, my mother-in-law lived down in Texas, and they were giving us a hard time up here because we weren't physically present. They said, no, you have to be physically present. I said, well, I'm an attorney. I don't think that's how the law works. But I don't know. Texas is like a different country. You guys do things differently. But you know, you still run into issues even with these documents. But if you have them, you know, you're in much better shape.
So every doctor, every hospital has multiple HIPAA forms, I think, and
Yeah.
you can't go to one without having.
Yeah. Yeah, and so if you're conscious and go into a hospital, they try to quickly get you to sign something. Okay, here's a HIPAA release. Who can we speak to? Who do you want making decisions? Because they don't want to be caught without. So sometimes, even though you have them, they'll still want you to fill out their form. You just write down the same people. But yeah, hospitals want decision makers. They don't want to be without them. So if you're cognitive and you know, awake, they're going to try to get you to sign something, which isn't a bad thing.
So would you go through an attorney again with this HIPAA waiver?
Yeah, and it's usually part of the package.
Yeah.
You know, usually when you get this planning done, you know, power of attorney, HIPAA waiver, healthcare directive is all part of your estate planning package. They're usually all done together.
Now, do we as a home care agency, you know, we deal with patients and families all the time, right?
Mhm.
And so sometimes we hear the daughter or son say, oh, I'm POA, so you can tell me anything, but that's not necessarily the truth. POA is different than
Yes.
this, right? So we have them sign our HIPAA thing, but like, we don't have proof that really, I mean, we really need to have that proof that it's okay for us to speak to the family member.
Probably should. Your
Yeah.
compliance will tell you
Right.
better than me, but
Yes, yeah.
you know, and
And
people
we
use
have tried to have those conversations with the family, like we, you know, technically we can't speak to you, and they, you know, they argue with us all the time.
course.
Right, oh, yes, you can, you know, but now it's, you know, it's clear that we really need to speak to that. We need the
Yeah.
signed HIPAA.
You should, and probably your compliance will tell you the
Yes,
same.
yes, right.
And people use a lot of these terms interchangeably.
Right.
So they'll say, I'm the power of attorney. Well, that's just financial, but they are
Right.
the healthcare agent, but it's kind of a general catch-all.
Right.
So a lot of these terms kind of get mixed in with each other. So I'm kind of used to it when someone says, oh, I'm power of attorney for my dad, and da, da, da.
Yeah.
We say, okay, let's see the documents, and we kind of have to explain it. But it is, power of attorney's become a general catch-all for a lot of this stuff. All right, I think we can move on. Okay, so when it comes to Medicaid or Title 19, you know, you have someone with dementia or other some sort of long-term care need where they're going to need advanced care, whether that's nursing in the home, you know, part-time, full-time basis, or having to go to a facility. And you want to apply for Medicaid, which basically means that the government pays for the cost of this care, not you personally. Why does that matter? For full-time care in Connecticut, in this area of Connecticut, you're probably looking at close to $200,000 a year. And depending on the facility you're at, that can be a little bit less, it can be a little bit more. Depending on what level of care you are, there are different level of care needs. Or if you have some sort of specific needs, again, that can wax or wane the price. But if you just take this general assumption, and I will say the cost of care is not going down, it is going up, and it is going up at a rate that's much faster than inflation or cost of living adjustments. So just like the cost of healthcare everywhere else. So it's very expensive. Just thinking at $200,000 a year to pay for someone's care, you're gonna go through money very quickly. In 5 years, $1 million gone. So that could be people's entire savings. So, what do you have to spend your money down on before you can apply? Now, there's certain rules. The person that's applying for care can only have $1,600 to their name. That sounds absolutely insane. $1,600. The healthy spouse can keep half of their assets up to around $150,000. All right. So not very much if you're playing by those rules. So what do people do? They see these general rules, they spend down to those levels, and then they come see me. And it's heartbreaking to see that, because there is so much planning we can do ahead of time to preserve assets before people even get into the spend down. So again, people of retirement age, we should start having around 70 years old, having conversations, because part of the planning, there's a timing to it. If you give property away, which we'll talk about in a little bit, there's a 5-year look back for Medicaid. So they do a 5-year financial audit and they say, did you give any property away that could have been otherwise used to pay for your care? So gifts to children, transferring property to children, all things like that can really come back to bite people. So because they're trying to do this last minute, they're saying, oh my God, we need care, we need to get all this money out of their name, and they just start giving it away. There are ways to spend down in that emergency need. Talk to an attorney. There are different kind of, not tricks, but by playing by their own rules, allowances that we have that are not well advertised, that are very technical, that an attorney that knows what doing will be able to preserve assets. But what is up for grabs, right? For everyone else, basically all your bank accounts. Your home, if you have to move out of your home and you no longer have a spouse or a disabled child living in the home, they say you have to put it up for sale. And once it's sold, that money has to be applied to your care. Even if you're on Medicaid, they'll kick you off for a little while. You'll have to spend down that money until you can jump back on. Second homes are up for grabs. Retirement accounts, this is a tough one. Some states, like New York, do not make you spend down your retirement accounts. They'll apply your income, those required minimum distributions you have to take, those get applied to your care in New York, but they don't touch the principal. Not Connecticut. Connecticut says liquidate, get rid of it. Annuities, life insurance, there's income limits to how much income the spouse that needs care, the person that needs care, is allowed to keep. I think it's like $73 a month. I mean, it's practically, they increased it from $69 a month. Very kind of them. Basically nothing. The healthy spouse gets to keep all their income. So there's certain things we can do using different annuity products that create a stream of income for a spouse that qualify for Medicaid protection. But those are only purchased at the time of Medicaid qualification. Again, highly technical stuff, but there is ways to preserve assets. Again, assets in revocable trusts, totally up for grabs, not protected at all. Assets in irrevocable trusts, if you are the beneficiary. So we see this a lot. We see people create irrevocable trusts. I don't know what attorneys are doing them, but the person creating them is also the beneficiary of them. That doesn't do us any good. So again, those would be accessible. Or we had one spouse pass away and everything went into a trust for the surviving spouse that was governed by this HEM standard, health, education, maintenance, and support, which is used in tax planning. And so people have documents that are very old. They weren't updated by an elder law attorney when they got a bit older. So one spouse passes away, it goes into this marital trust for the spouse, but it has health, education, maintenance, support. We have health in there, we have maintenance, we have support. The state says, yay, give us the money. All right, it is not protected. estate assets, reimbursement, if there are any assets left in the estate, like the home that the spouse was living in, things like that. When that person passes away, the state will come in as a creditor and say, pay us back for that care you received. That's why having that power of attorney, when we go to apply for Medicaid, we are shifting assets around between spouses. We are loading one up more than the other. We're buying annuities, different financial products that protect assets. We're doing a lot of maneuvering that requires this one simple document. Without it, we have to go get a conservatorship and we're waiting a month plus for appointment, which is costing $18,000 a month at this point. So it's costly not to have it. But as you can see, there's a lot up for grabs here if you do no planning. Okay, so we'll move on to the next slide. How do we prevent against this?
It looks like everything.
So there is a simple way. So this is the Medicaid will problem that we see all the time.
Be nice to your children.
So we have someone's husband and wife have an estate of 800,000 total. Okay, they have a simple will from years ago that says when I pass away, everything goes to my spouse, right? People that have those wills, typically, they don't even need the will because they're holding everything jointly anyways. House is owned jointly, all the bank accounts are joint, retirement accounts say my wife or my husband is the beneficiary, same with life insurance. So one spouse passes away. Sorry, we killed off the wife first in this one. That wasn't nice of us. I think we corrected in the next slide. But anyways, now husband inherits everything. Now he needs later on care. And what we see statistically is single spouses need advanced level care more than married couples. Why? Simple answer. The healthy spouse is a built-in caregiver. They defer that need for that additional nursing care or the need to go to a facility. They can still live at home and that loving spouse helps out tremendously. But when they're not in the picture anymore, we need 24-hour care at home. We need to go to a facility. So now what happens is we have this husband that's got $800,000 in his name. It all has to be spent down to $1,600 before the state will pay. So what ends up happening, it all goes to the nursing home. When that spouse passes away, there's nothing left to go to the children or a charity if that's where you're leaving your money. And additionally, that surviving spouse that's in the nursing home, they have no money to pay for anything. Haircuts, a new TV, some new clothes, better hearing aids. There's no money there to provide for it. So they're relying on their children or other family members, if they have them, to make up that gap. Which is, as parents, nobody wants to feel like they're a burden on their children. But this is the situation we're left with where we have simple wills and jointly owned property. So we'll go to the next slide. The solution. All right. So when we're doing our planning, we like to get rid of this joint. Joint is bad. I know you go to the bank and they say, oh, if you're joint on the account, you avoid probate. Gosh, it might avoid probate, kind of in Connecticut, but you're leaving it all susceptible to be taken if one of you needs care. All right, so what we like to do is try to equalize the estates between husband and wife if we don't have a need yet, right? We don't know who might get ill first. We don't have a crystal ball. So we try to create division. So we get rid of this joint. So like your home, most people own their homes jointly with their spouse. What we do is we change it. It's a very simple deed to what's called tenants in common. That means you each own 50%. Where a joint is, I always like to compare things to food, like a pizza. It's a pizza that's not sliced. You each own this pizza. Tenants in common, I slice the pizza in half. You each own 50%. So if one of you passes away, 50% of the value of that home is now going to be protected.
Josh, what's the term?
Tenants in common.
Tenancy.
Tenants in common.
Okay.
And so bank accounts you can't put in tenants in common. So if there's especially larger savings accounts, unfortunately, we like to split them, create two accounts. Brokerage accounts, they can put in tenants in common. We do those. Beneficiaries for life insurance, retirement accounts, we don't want them going directly to the spouse. Where do we want them to go now? We create a trust underneath your will. Okay. This is a supplemental needs trust. It's for the surviving spouse's sole benefit. While they're healthy, they get as much income in principal as they need. But if they become incapacitated, nothing in this trust is susceptible to the spend down anymore. All right, and so basically the income in principal will only pay for things that the state doesn't pay for. So while the state will pay for Medicaid, the long-term care at a facility, full-time nursing, because Connecticut's nice, you can either get full-time nursing at home or in a facility, the state's paying for all that, but you need new clothes, a bigger TV, hearing aids, whatever it might be, there's still money there to provide you the standard of living that you're accustomed to. Then when the surviving spouse passes away, the state cannot attach any of it. It all can go to the children. So again, this ends up kind of keeping what your original goals of your estate plan are. Now, what's the catch? There's got to be a little catch to this. Unfortunately, because of this trust, you cannot be your own trustee. So a lot of times people name their children as the trustee because of a close relationship. Other people, if they don't have that, we have a conversation about some other possible alternatives. But the idea is this money is all there for your use, for your benefit. But we just need an independent trustee, because if you have the power to distribute money to yourself, the state can force you to distribute that money to yourself and pay for your care. Now, if we're in a situation where someone is starting to have early onset signs of dementia, or we've done this planning already and they're starting to have those issues or another long-term care need, we shift the assets. So we kind of start playing a game here a little bit, right? We look at, okay, somebody has need now. We want to shift all the assets to the healthy spouse. Because God forbid that healthy spouse passes away now, we want it to go into a protective trust, not protect 50%, try to protect closer to 100%. Now, what if we get a diagnosis where one of those unfortunate ones where a doctor gives you a timeline? Whether this is the healthy spouse or the unhealthy spouse that's not on Medicaid yet, but we're told 4 months, something like that. I tell clients, you don't have to remember what to do, just remember to call me and we'll figure it out. There, we want to do something counterintuitive. We're going to want to shift all the assets to the unhealthy spouse that has this bad diagnosis. That way, we know that they're most likely going to pass away first. It's going to go more like 100% into this protective trust, because they're not going to need Medicaid because they have a short lifespan. So there is a little bit of kind of game time decisions that need to be made, but you want to have this plan in place. And at the beginning, we try to divide you guys 50-50 if we can. And, if we get this kind of heads up of an issue, we make adjustments as we go along. Okay. But it's important to get this done early, because one of the problems we run into is if someone is not capable to sign a document, they can't sign a new will. So sometimes we just do one for the healthy spouse and we use that whole power of attorney to load all the assets onto the healthy spouse, just in case, something happens to them. And that's the best we can do. But we want to get these documents in place while we can. So that's our solution with wills. They work really well. The other nice thing is, while both of you are alive, it doesn't affect anything. I'm not changing anything. I'm not locking up any of your money. It's all available to you. It's only after that one of you passes away that we protect 50% plus, if we need to. And so it's a really great, benign solution. Who should have this? We were talking about this earlier. Anyone that has under $2 million of liquid assets. So that does not include real estate. If you have under 2 million of liquid assets, bank accounts, retirement accounts, investment accounts, you really should be focused on this type of planning. This is what you should be doing. And that amount might be going up a little bit with kind of the increases we're seeing. If you have over that amount, especially significantly over, you're almost like self-insured. The spend down would take almost so long that it wouldn't matter, unless we have a spouse that has an early onset. Then that changes the equation a little bit, because we know we're going to need the protection. It's not so much like an insurance policy. But for anyone that fits into that category, this is what you're wanting. You know, anything else, a simple will, revocable trust is just the person selling it to you or doing it for you. It's irresponsible, in my opinion, dangerous. Not to speak harshly, but it's true.
If you're gonna talk about this later, just let me know, but 5-year look back, 7-year look back, let's say it's year 4. And somebody gets smart, right? And like, oh, now I'm ineligible. Is that actually true? Like if you have a need and there's. Like, can you still apply and maybe pay a penalty if you need Medicaid, or it's all or not that?
So there used to be a penalty that they would let you play, and the technique was called half a loaf. So what people would do is would give away half their money and pay the other half of their money in a penalty. The state got wise to that many years ago. That does not work anymore. So even if you're 4.5 years in and you need care, they're going to disqualify you. And what they do is they disqualify you for a period of time based on the amount of the gift that you made, regardless of when it was made in that 5-year period. So they'll say, okay, you gave away $20,000 and our Medicaid rate is this, you're excluded from care for X number of days, which can be tough in situations like that.
And they look.
Oh, they look.
They will find, I had a client who was giving her son minimal, $100 here, $50 here. She was applying for Medicaid and we had to go back to court and really fight the fact that they would refuse her application because she was gifting money. Even though it was a very minimal amount of money, it was considered a gift.
Yeah, and so, especially if there's an early onset something or someone's been diagnosed, the way we treat our financials really needs to change. Christmas gifts to grandchildren, I know they're really nice. We might want to think about different ways of doing it. Writing them checks, things like that. They're gonna look, they used to say they only look at transactions over $1,000. Now they look at low transactions in the hundreds. It's become such a stringent process to go through, and they do very, very detailed financial audits. If they're not sure who a check was made out to from 4.5 years ago, they ask you, like, can we get a copy of this check? What was this payment for? People used to be cute and try to say, well, tangible personal property is not included, right? That's one of the rules that they say. So people were going out and buying a whole bunch of gold, right? Because that's tangible, tangible personal property. High valued collections, jewelry, gold, things like that are all part of this. So don't think you can go out and buy a giant diamond ring more as a way to hide assets.
What about, if you have 529 set up for your grandkids?
Yeah.
And that money is contributing there every month.
You gotta stop contributing to 5.
Wow.
I didn't know that. That's.
If you're not the owner of it, and you don't have access to take that money out, it is not a nice process financially. It's great because people get their care paid for. Working with an attorney, doing all this pre-planning, you can protect a whole lot of money. I mean, we get people protected, preserving all or people, on Medicaid and protect all their assets. There's a lot of maneuvering that goes on. There was pre-planning that was done ahead of time. There's the game time planning, but there's a lot that can be done, but it's tricky. And the states, they don't love it. It's causing Medicaid applications used to be done in 4 months. We're seeing them go a year, 2 years now because of the information that they want, especially people that have a little bit messier financial situations. They turn over every stone. And I had one as an example, a nice elderly woman. She paid for everything in cash. She'd go to the bank, take out $500. She'd go to the grocery store, go to the cleaners, pay for everything in cash. I can't believe we got it by the state and we convinced them that that's just what this woman did. We had to go to the grocery store. Luckily, it was a little local grocery store and get an affidavit that said, this woman pays for cash every time she pays in cash every time she comes in. Because they were like, nope, we don't know where this money is going. We're assuming that they're gifts. So it is tough. So the way that we treat ourselves financially, making cash gifts, making check gifts to grandchildren for weddings, births, graduations, Christmas, Hanukkah, whatever it is, really needs to be dialed back, especially if we have someone that, is gonna need care in the next so many years, or we think that might. Which is tough, because we're all loving,
If you pay for a grandchild's tuition, is that considered?
Oh, yeah.
Yeah. What if you pay for like a service in cash, like a high, like, contractor service or something, few $1,000s in cash, they're gonna wanna know where that
Yeah.
went.
Yeah, and so one of the things that we do, when we're applying, and this is a little outside the scope of our conversation, but kind of that we need to apply, how do we spend down? Well, the home is protected, let's increase the value of your home. Especially if the spouse is gonna be living at home, all right, let's get comfort height toilets in there, let's widen doorways for wheelchairs. Hey, you needed to upgrade your kitchen, now's the time, you needed that new roof, let's put it on the house. Anything that might add equitable value to the home, that's all part of this smart spend down that a lawyer can kind of help you with. So if you're paying fair market value for a good or a service, that's cool. That's totally fine. You can still run your life. You just can't give money away. So again, that's why we need the care agreements and the leases with the kids if they're helping us with stuff or we're living with them, because we need to create that paper trail. I tell people cash is out the door, no more using cash, only use checks, write on the memo line what everything was for, or use a credit card, that's easily tracked. So that's kind of our advice when someone's kind of in that planning need.
So all of this is planning for Medicaid.
Yes,
I mean, if you've got big assets and you really don't care.
Correct.
How much should you?
care you care, but you have so much that the spend down would just take so long that you would never get. I have people that have significant assets that don't care about that, and they're like, nope, I don't care if it's more protective structured, I want to protect as much as I can. And we can do that. I don't think it's as valuable as it is for kind of the population I was talking about. For them, it's going to be the most valuable.
2 million is that kind of number that you work with?
2 million liquid, so not including your real estate. If you have under 2 million liquid assets, then this is just a must have, in my opinion. Because you think about $2 million, that could be 10 years worth of care. If you have someone with an early onset diagnosis, they don't have the spouse there anymore, it's just too much for the spouse to handle, they're having health issues of their own. $2 million can be gone in 10 years.
I have a question, I don't know if you covered this, but I work with a lot of family members who, they live together, they're not legally married, they're older. Does this look very different for them in a situation, legally?
It does, because they're not married. Connecticut's not a common law state, so they don't impose that marriage label on people that cohabitate or or domestic partners together. So they would have their plan would look different. They could still put things in protective trust like this for their partner. That way, if their partner ever needed care after they passed away, they would have protected money. And there's other family planning reasons why we would do that. But for the actual Medicaid application, that partner would not be included. Their balance sheet would not be included there. But we would lose opportunity of shifting assets between spouses, which becomes helpful. So it's kind of it teeters, like in some sides, oh, it's a benefit, their assets aren't included.
They're married.
On the other side, we lose some of the planning techniques we can use that you need a married couple to do.
And the same would apply to $2 million.
Yeah.
For them, for those people as well.
I would say so, but that's why a lot of times people come and see us after they've had a spouse pass away and they're in their 80s. Our planning becomes much more limited because we can't do this protective will. All the assets are on their side of the fence now, and we've lost that opportunity. So doing it early, that's why I said people of retirement age around 70 are a little over 70, and you're falling to that asset class. This is what we're looking at for the most part. Okay. So the last planning technique we're going to talk about is protecting your home, right? This is typically the most important thing to most of my clients. It's a lot of times their largest asset, especially what's happened to real estate values in Fairfield County recently. The house is, very, has a lot of value to it. It's also, a lot of people have lived in the same house for many, many years. They bought it for $50,000 and now it's worth 800,000, it's crazy. But they have their whole life there, and the thought of losing their house is probably one of the more kind of mentally traumatizing thoughts. So how can we protect it? Right? This is where the use of an irrevocable trust comes into play. So I said irrevocable, not irrevocable, or not revocable, irrevocable trust. What we do is, and I'm going to try to make it not too technical here. One, the first hurdle is you cannot have a mortgage on the property. In order to transfer a home or real property into an irrevocable trust, you cannot have a mortgage on it. Banks don't like it. It causes the mortgage to become due immediately. So that's the first hurdle. Sometimes I have clients with very small mortgages left, and we're looking at a situation, we're saying, hey, that 5-year clock that we're going to talk about in a second, that's going to start running. Just pay it off. Let's get this going. And for most people that were, doing this for retirement age, their goal is typically to have their home paid off by the time they retire to kind of lessen their bills. So first is, can't have a mortgage on the property. All right, then we transfer the home into this trust. That's where the 5-year clock starts ticking, all right? It starts ticking from the day we make the transfer in, not the day the trust was created. That's our 5-year clock. Now you say, well, what the heck? I just gave away my home. Isn't that a bad thing to do? Well, what we do is you guys or whomever is giving away their home, they keep life use in the home. All right. You can keep life use in property and real property, which is nice. That means no one can ever throw you out. You are considered the owner of the home. You still have to pay your real estate taxes, the insurance. You have to have, pay to have the driveway plowed. So it's just like you're still the owner. If you receive a senior citizen discount on real estate taxes or veteran discount on real estate taxes, every town has different rules with that. You still qualify using this, okay? So house goes in, you keep life use, you are still the owner. No one can kick you out, right? You cannot be the trustee of this trust. As we kind of said before, with irrevocable trust, you can't be your own trustee. So who is the trustee? Typically, people pick their children as the trustees of this. Now, the house is in there. After 5 years, the value of that house is fully protected. You can go on Medicaid. They can't touch the house. People always ask, well, what if I want to move? I'm downsizing. My kids moved to California. I want to go out there and be with them. I don't want to be chained to this one property because we put it in the trust. Not a problem, okay? The way that this is set up, the house can be sold within the trust. The sale proceeds are now within this protective trust. So we still have that protection. The trust can buy a replacement residence. So if we downsize from a $500,000 house to a $200,000 condo, now we have a $200,000 condo in here plus $300,000 of profit in this trust. That's now all protected. So we stay within this protected frame. Okay. People ask more technical tax questions. Well, now that I put it into a trust, when I die, what happens? So typically when you give away your property, so if you just took this house and gave it to your children, the tax rules say they inherit your cost basis. So if you bought this house for $50,000 and now it's worth $500,000, when your kids go and sell this house after you pass away, they're going to have $450,000 of capital gain that they're paying 20% on. Boom, that's a bad hit. If we use this trust and you pass away with the house in this trust, you get step up to the current fair market value as of the date of your death. It eliminates all that capital gain. That $450,000 is gone. Your children's new cost basis in the house is that $500,000. So if they go to sell it, no capital gain. That is a massive tax benefit to doing it. The other benefit is if you sell the house while you're still alive, you maintain your $250,000 exclusion of the first profit. So just like you still own it, not to get too technical, but you don't lose out on that as well. The other reason we like using this house trust rather than giving the house to your kids is kind of something I touched on earlier. All right, you gave your house to your kids. We know they're going to pay a big tax amount when they go to sell it later, but they get divorced. They get in a car accident, they get sued, they go through a bankruptcy, they just have a tough time in life and they have some sort of creditor. Your home now is an asset of theirs to be to be attached or leveraged in a nasty divorce. I've seen that, and it is nasty. You give me what I want, or your parents are out of the house. We do not want that to happen. Giving property to your children is not the way to go. Using trust structures, yes, they cost money, but it provides you protection. It's well worth it when you run into one of these nasty situations. So not only after you give this house to the trust is it protected from your creditors or Medicaid, it's also going to be protected from your children's creditors as well, divorcing spouses or whomever they might be. So again, we get that added protection by doing this. Some people say, well, we did all this, but I need care before 5 years. Now what? I made a disqualifying transfer. Am I stuck? Am I going to get disqualified? The answer is no. We have a couple options. If we're that 4.5 years in, right, and we have some money, we try to private pay to get over that 5-year hurdle. The investment of paying half a year, 1 year, is worth it depending on the value of the house to protect the home. And if we have those funds available to do so, typically a lot of times we have to spend them down anyways. We could do it in a smart fashion where we private pay for a period of time to get over that 5-year hurdle, and then we have the house protected. But let's just say we do this 6 months later, things go downhill very quickly. We need care now. We don't have enough money to pay the 5 years. Are we stuck? The answer is no. Your children are the beneficiaries of this trust. So the trustees would distribute the house out to the kids. They would give it back to you. Basically, we undo the transaction. It's like it never happened. So we tried our best, but unfortunate timing of events, we had to undo it. We lose that protection we were trying to have. I've had other situations where we put this house in a trust, 3 years go by, and a spouse gets that bad diagnosis, right? They get that timeline. Well, for 3 years in, we have another 2 years to go on this trust. But we did those protective wills we talked about. What we did was we transferred the house out to the kids. They gave it back to dad who had the bad diagnosis. He died. It immediately goes into this protective trust under the will where there's no 5-year look back. And we get immediate protection. So you can see how this whole plan kind of works together. It evolves together. And when these issues arise, I always tell clients, you don't have to remember what to do. Just remember to call me and we'll figure it out. Because it does get really technical, and for a lot of this type of planning, for attorneys that do this, one of the other things is how do they bill? A lot of attorneys that do this specifically, they don't bill for phone calls, emails, questions. I have clients call me up, hey Josh, this is going on. What should I be doing? That 15-minute call, you should not be getting a bill for, in my opinion. So when you're working with someone on doing this, that's something to ask them. If they call you up afterwards and have a question, are they going to bill you for that 15-minute call? Of course, if you're making changes to the document or there's more involved planning, there's going to be a billing for that, right? But kind of staying in contact, being able to ask questions on how this whole complex plan works, you shouldn't be being billed for. So that's another thing, going back to choosing an attorney.
Josh, can you explain where it says assets are protected from children's creditors unless the child is a trustee?
Yes, so a lot of times we have the children as the trustee, and then we have an independent trustee as well. So we want the children to be the trustee because they're the ones working with the parents. And there's that security. But if they're also the beneficiaries, their creditors can say, you're the beneficiary of this trust. While there's life use on it, they can't attach anything. But if we're past that life use, the parent has passed away now, or the creditor has a judgment, they can always attack it unless we have an independent trustee, which could be another family member that's just not a beneficiary. an uncle, another nephew, sometimes people use their attorney. That gets a little bit more technical.
So you make your children the beneficiary, but not a trustee.
You can make them the trustee, you just need another independent with them. So, or we limit their distribution power, so they can't distribute to themselves.
And is a trustee ever like, can you make your attorney your trustee?
You certainly can. People, a lot of times people use attorneys and accountants before they get to banks as trustees, for a host of different reasons, but. That's all stuff that kind of gets into the details, and when we're meeting and selecting trustees, we kind of have these more in-depth discussions. But good question. And again, upon your passing, the house or the value, whatever's in that trust, goes to the kids. This slide just kind of breaks it apart, step by step, but it goes to the kids without any sort of interference by the state. So again, the state can't put a lien against the property, or become a creditor of the parent's estate to reclaim that. So again, we're able to pass on that value to your children without interference. Yeah.
I'm getting very specific, but I've seen this too. What if there's a divorce in that period of time, the 5 years? There's a couple living in the home, they decide to do this type of trust. What happens to the property?
Yeah, so that becomes a little bit more complicated. They both have a life use in the property unless one gives up for the other. But because they no longer own that property, it gets tricky. Definitely gets tricky on how to handle that. So again, a lot of times we're doing these when people are much older, so the divorce rate goes down when people reach a certain age. It still happens, without a doubt. And yes, if someone thinks that they might be divorcing a spouse, putting it into a trust with them would not be my advice if they're having marital issues. And again, you don't have to be married to put your house in this trust. We have single people do it all the time. So while with the wills, a single person might lose some of that advantage, we have surviving spouses that say, okay, well, what can I protect? And the house is a big one. And so we use that trust for single spouses as well. All right, getting towards the end here. So common mistakes, all right? I think I've done a pretty good job explaining a lot of them. Not having anything done. Just kind of rolling into the darkness without a flashlight. Not the way to do it. It's not good for you. It's not good for you financially. It's really bad for your family. It causes so much more stress in a stressful situation. It causes tension, family fighting. Forget the financial aspect of it. I've seen more families ruined by this than anything else. Like I said, I want everyone to have Thanksgiving together. Not updating your documents. Again, you're like, oh, I did a will. I'm good. As you can see, there's different types of wills out there. There's different types of situations. We have planning for just about anything. And that's not just at this level. You might have a child with a disability that might need Medicaid, that might be on state benefits. We still want money going to them and kicking them off. There's special trusts that we put under your will so they can still benefit from their inheritance, but the state doesn't. And they get to keep their programs, and they don't have any money attached. So regardless of these situations, we have planning for it. So old documents that were done, might just need a look, to be taken a look at. Not planning for a disability, one of the things I always hear, that's never going to happen to me. I'm just going to drop dead. I'm never going to have a disability. Or if I'm disabled, just take me out back and put an end to me. I hear these things. And people are sincere when they say them. They're not as tongue in cheek as I might make them sound, but people don't like facing difficult things. Death is one thing. Becoming disabled, dealing with these diseases, frankly, is a lot scarier than death to a lot of people. Especially people that have lived it with family members. So they avoid doing this type of planning, like, if you avoid a situation, it won't happen. That's not going to help you in these situations. It's like an insurance policy. It's sometimes better to plan for the worst and hope for the best. It's always great if we never have to use this type of planning. It's still going to do what a will would do. It's going to have great family planning in there that your old will might not have. We just didn't have to use any of this Medicaid stuff. But if we need it, it's there. All right. Putting your child's name on the deed. I think we just covered that one, so we won't relive it, but bad idea. Choosing the wrong person to handle your estate. So again, this is not just handling your estate, but naming as your power of attorney, your healthcare agent, trustees. We need to put a lot of thought into these. And not even just who we're putting, but are we putting people together that shouldn't be together? I had an estate that just went on for 5 years, wasn't even a big estate. Brothers just didn't like each other. Both brothers had attorneys. One brother was exceedingly difficult, caused it to go on for 5 years. I can't tell you how much, there wasn't much money there, but it was pretty much all lost, either through loss in market value, and timing of things, and just attorney's fees. I always say you don't want to make the attorneys the beneficiaries of an estate. So we don't want people fighting. So we want to prevent that by not putting people together that shouldn't be together. Procrastinating, putting it off. I know you said it, this is not sexy stuff. You know, it is not how people, you know, sometimes think of, well, it would be really nice to do this with these few dollars. Really doesn't seem so nice to go get a will. But I think you could see here, in the end, it's a real net cost savings, a big one, if you need it. And you're just, the security of knowing that you have it in place is also good. This looming of, oh, I need to do this every year, only builds. So stop procrastinating, just get it done. It really is a set it and forget it. Once you have these in place, you know, really, unless there's a change in health or major change in health or wealth, or family situation, you really don't need to update these. These should last you for quite some time. All right. Again, meeting with the right people, whether that's, you know, an attorney, financial planner, tax professional, you know, you should be working with people that have an understanding of this, have an understanding of where you are in life, where you plan on going, and the possibilities that kind of lurk out there, especially with this stuff. There's a lot of financial planners out there that have a lot of experience with this, that have either been doing it a long time, have gotten certifications in kind of this elder law financial planning, or have a lot of elderly clients that work closely with the attorneys. You want a team, if you're gonna have a team, you're gonna want a team that works together and that knows about this stuff. My favorite one is thinking your friends and neighbors know more than your attorney. I get a lot of pushback because somebody over a fence told them something. You know, there's a lot of just misinformation out there now more than ever. There's a lot of bad information on the internet, on apps on your phone. I mean, it's all nonsense. People talk in generalities. The laws in California, not the same here. Laws in Florida, not the same as they are here. These ideas of avoiding probate, everyone needs a revocable trust. A lot of them just don't apply in Connecticut, you know, and you know, people aren't experts in these areas and they're just giving general advice because it gives them a lot of clicks. They give a scary tagline out there. They talk fast. They got flashy things coming up on videos, you know, a bunch of scary words. And you're like, oh my gosh, this is what I should be doing. There's also, hate to say it, you know, attorneys get a bad name. I don't want to give them a worse name. People sell expensive documents that people just don't need. You need this type of will. You do not need a revocable trust that's going to cost you twice as much money. And you know, you don't need to pay for a will that's just plugging your name into a document that just says I give it to each other. Why even have it? You know, there's bad information, there's people with not so great motives giving bad advice. And then there's just people that just don't know any better. They hear something, they think it's a good idea, they think they're being super clever, and they're outsmarting the state. It's like outsmarting the IRS. Like they catch up to you. You got some answering to do. You don't want to be doing that answering when your spouse needs care. You know, and then you think you're going to be, you know, not get it. It's going to cost you a ton of money. You're going to be saying, really wishing you didn't do that. Just talk to an attorney. It's worth it. Even if you have to pay for an initial consultation, it's worth it. It's worth the hundreds of dollars that it is. You're going to get something out of it, especially if they know what they're doing. And once you have a relationship with an attorney, like I said, if you have questions, you can call and ask. It shouldn't cost you anything.
I think it's such a gift for children and your loved ones. I was at a client's home yesterday and she showed me a binder. She went to a lawyer, he put everything together for her. It was a beautiful thing to see, and I know that her two sons were very fortunate to have everything. They know exactly what to do when she's sick, when she passes, all there. So it really is so important and so significant for people to make these plans. Thank you. It was chock full of information.
Yeah, I know, I did a lot of talking. You guys asked some good questions. We have a little bit more time. I know there's people up on the screen. I don't know if anyone has any questions up there or any other follow-up. I know too that this stuff can be really personal. It can be a very direct situation that, you might not want to share a question because it's revealing of something. Feel free to give me a call. I'd be happy to take your call. I'd be happy to do a free consultation for attending this seminar. But if you have a follow-up question and you're not here in the room, feel free to give me a call or email me. I'd be happy to answer.
Josh, back to the different states have different rules. So given where we live, that we're so close to different states, if I make a trust for my Connecticut house, and I decide to downsize, and I go to a condo in Purchase, New York, does the trust remain in effect?
Yes. Yes. And frankly, our rules are more stringent than New York's, so you're in better shape. New York rules are a little bit more open. So sometimes when those trusts come over the border here, we have a little bit of a problem. Because you're allowed to have income distributions in New York, Connecticut, you're not. So there can be a little friction sometimes. So if you do move over the border, it is always a good idea just to have a review of your documents to make sure that you don't want to be afoul of the rules.
Okay.
If it costs you $500 to get an estate plan reviewed because you moved somewhere new, well worth it.
But the look back will remain in.
Yes. Yeah, you don't start a new look back for moving.
We still one of the most expensive states for end of life.
Um,
I think we were number 2.
yeah, we're up there, Connecticut, New York, Massachusetts. I mean, they're all expensive. California, a lot just has to do with cost of living. Anywhere where there's high cost of living, cost of nursing care and facilities just going to be more, just like anything else. All right. Well, I hope this has been informative for all of you. I love sharing this stuff. And I hope that came through. Like I said, any questions, give me a call, send me an email. I'm happy to email you a copy of the presentation if you wanted as well.
And you're in Richfield?
Yep, right down the street, up on Grove Street, one of the buildings behind the Hideaway, that office park where they have a lot of the doctor's offices, things like that. And then we have, just in case people on here, because I know RV and Health expands northward, we have offices in Danbury, New Milford, and Litchfield as well. So we kind of go right up the western border of the state here.
This was very helpful.
Thank you.
It's really
so much.
important.
My
Thank
pleasure.
you so much.
Thank you.
And thank you, everybody. This is, we're heading into, I think, our last presentation is June 18th. And it is end of life and hospice care. And I'll be speaking with a social worker from RDNA Health, Deb Pila. And it's a heartwarming one. It's a difficult one, but it's going to be a great one. So please consider attending. And thank you so much for coming today. Again, I'm Danielle Tavy. This is Gigi Weiss. And together with our marketing department, we've been running this dementia series, and we hope it's been helpful for you.
It's really a great service you're giving everyone by having this stuff, because it's tough to talk about. People have questions, and it's scary to go on the internet and get information. So you doing these is really a service.
And if there's anything that you guys want to hear about, let us know and we'll see if we can present it.
Set it
This is the first of a series that we started in March.
Right,
or-
we plan to do this series, hopefully yearly, but there may be other topics, that might be of more interest to you. Or things that you've been dealing with that you want to learn more about, so, let us know.
And we do have, if anyone, we do have the dementia support groups here also. That
Yes.
is here regularly.
Yes.
Anyone is dealing with for caregivers and patients.
Wonderful resource. I really didn't know it existed.
Well, I mean, yeah, this was a new thing that we thought that the people dealing with or that have dementia may find
Is
helpful.
it on the website?
Yes.
Yes, all of
number,
it,
everything's
all
on
of
the
it.
website. You can also
Yep.
subscribe to the newsletter. It tells you all the, upcoming workshops. There's a wealth of knowledge. I recently sat in on one on nutrition and I learned
Mhm.
tremendous amount. So we have ongoing things that go on all the time here. And then we do our outreach to the community. So you could subscribe to the newsletter and we'll share all that information.
Just so you know, if you're wondering, I have cards in my bio over there if you were looking for that information or just wanted to learn more about myself or our firm.
Thank you.
This was tremendous. Thank you so much.
Thank you so much, guys.
My pleasure. Thank you, guys.
I can follow up.
I know.